Friends, today I'm going to talk on landmark judgment uh, by Supreme Court on the subject of daughter's inherent right under Hindu Succession Act. And when I go through that act, then I've gone through the uh, whole Hindu Succession Act. Once you go through the whole decoding of this act, you will be able to know what are the rights of a woman as well as male, and everything would be detailed, would be understandable. When you die intestate, as well as males and females right, how the whole Hindu Succession Act works. This is the presentation. You'll be immensely benefited and you had a lot of clarity in this regard, because nowadays female has got billions of crores of rupees wealth are available to them through their right over the property of father, mother, grandfather, great grandfather, and these properties as land price has increased in billions, and people are taking them righted. So my presentation is on this. I am CA NITIN PATHAK, ISACA past president, and we are continuously talking on different subject on information technology, income tax. We are going to talk on the budget also. And as I am a founder president of ISACA chapter, we guide people to do different courses where they enhance their value in their life, in their job, in their profession, in their career. And today I'm going to talk on this coming Friday. Manish Nayak is going to talk on security and its myth. Manish Nayak is a learned and very sharp on the subject. When you hear him, you would develop a lot of clarity on the subject of speaker on security and its myth. Next, that is coming next Friday, we are going to take liability of internet intermediary as per Income Tax Act 2000 by Advocate Avichal Sinha. He is from Bangalore. He has taken the class. He will take again this subject. And I'm going to talk on the budget also. Instead of other than the subject which we have mentioned here, we are going every week. We are covering this subject. One is security myth liability analysis of union budget by Nitin Pathak. That is, I will take on this on 11th. Cyber security by Samir Pandya. Cyber security by Khushru Doctor. Tips of training of share and FNO by Bhaumik Kantharia. He has written a book on dealing with shares. Abhishek Jain, the learned speaker who has already talked on the subject of startup, which is available on blog. We are going to continue this talk on Zoom as well as physical. Now physical lectures we are taking it. But this now we're going into the subject proper. Okay. This landmark judgment few days back been on NDTV. From there I take it and I like the subject, and I've been seeing that females are being taken granted as far as their right is concerned. Now Hindu Succession Act talk about this, and 2005 there is a major change in the right of a female, and which has been discussed including the judgment and everything we are going to discuss. It is helpful to even advocate also who are practicing in the field. There are many judgment are also there, and many, even if anyone who is not interested in the property, but once he knows that, he will be able to guide himself or anyone else on the subject. With this, we are going ahead. Importance of will भी यहाँ cover हो जाता है. मैंने importance of will के लिए separate कोई भी slide नहीं रखी है. But if you don't prepare a will, it will go intestate, and the whole act, Hindu Succession Act, will follow. The judgment was discussed in NDTV. Can inherit self-occupied property in the absence of will. Preference over daughter. पहले जो class जो बोलते थे, इसके ऊपर जो daughter और niece और nephews का right था, 2005 से ये concept change हो गया. daughters to inherit the father's self-acquired property, daughters to get preference over other collateral members such as son, daughter, and brother, son of deceased father. This is a landmark judgment. Daughter to get preferential even if the father lived in a joint family. Clear that ancient texts, smritis, and even judicial pronouncement have recognized the right of several female heirs and wives. Daughters' right foremost among such is recognized here. Daughters to inherit father's self-acquired property if no will, case date back to 30 years. Family property dispute arisen. In this case, the father died in 1949, woman died in 1967. The case related back to 37. The trial court as well as High Court has dismissed in favor of against the daughter. And the Supreme Court in the judgment said that there would be fundamentally daughter will inherit the right, though it is before 2005 in the act when Hindu Succession Act was changed in 2005, still she was entitled for. This is a landmark judgment which would be available on blog also. Now I am going to decode the whole act. If male dies, if male dies intestate, the property will devolve upon. अगर मैंने will नहीं बनाया तो my property will be devolved on the basis of Hindu Succession Act. If I have written a will, then it will go according to the will of mine. The act applies to Hindu by religion, including Buddhist, Jain, and Sikh. The act does not apply to Muslim, Christian, Parsi, and Jews. The act apply to child and legitimate as well as illegitimate child. We are discussing some of the concepts which will enable you to understand how the devolving happens in the coming slides. ये इग्नेट है. Ignite is a concept which are very important in that last leg of the discussion. एक second ना. When two persons are related to each other by blood or adoption, but wholly through males. थोड़ा आवाज धीमो करजो ना. When two persons are related to each other by blood or by adoption, but wholly through males, they are said to be ignate of each other. Section 3(1)(a) of Hindu Succession Act defines that the ignetic relations may be male or female. It starts with the male, okay, and there should be a male member, and it follows and above and below that. For example, your father's brother, grandfather's father, Pardada, are called ignate in ascending line. Your brother's son and daughter, ignate in collateral line. Collateral means not exactly above line, but collateral means side में आ जाएगा. Your sons and daughter are ignate in descending line. There must be a male in the start of each relationship. Ignate कहाँ से start होता है? Male से start होता है. Hence, it will call ignate. It must be remembered the ignate relationship by blood and not by marriage. Ignate, अगर आप देखोगे तो your father is a blood relation, father's brother is a blood relationship. Everything is going by blood relation in case of ignate. Ignate का concept सबसे last है, but I discussed here because these are the two concepts which is very important to understand. It's very tough to understand also. That's why I taken tough to call right now. When two persons are related to each other by blood or adoption, but not wholly through males. If the two are related through female, they're said to be cognate of each other. So ignate and cognate. Cognate start with the female gender. Okay. For example, your father's sister's son, my father's sister, which Maggie, female gender, would be a cognate. Similarly, your brother's daughter, son, would be your cognate. Just remember a simple rule that whenever relationship of a person with another female or more than one female intervenes anywhere in Indian line of relationship, one is cognate to other, thus the daughter's son. there must be a male in the start on each line of relationship. Hence, it will be held as egnet, and son's daughter is son's daughter, son, and daughters are cognate. So, ye egnet and cognate are the last line of property available to them. If they are not there, the property goes to government. Okay, which is the concept full blood. Full blood means me and my wife, my son would be a full blood. If I may remarry somebody, then it is half blood, and that son is a half blood of each other. Okay, clear? मैं आपको full blood पहले बता दूं. Section 3(1)(e) of Hindu says 2 persons are said to relate to each other by full blood. They are descended from a common ancestor by the same wife. If I have a different wife and the son or daughter of them are not called full brother or full sister, they are called half brother and half sister. As either of these two are different. Hindu Succession Act, these concept is also have a priority in selection of an intestate heir. अगर कोई हेयर इंटेस्टेट हो गया तो इनका हेयर के टाइम egnate, cognate, full blood, half blood, uterine blood. These are the concepts which will be used there. Section 3(1)(e) of the Hindu Succession Act. 2 persons are said to be related to each other by half blood when they have descended from a common ancestor, but by different wife. The stepbrother, sister, fathers are different, fathers different wife, each other are called half blood. Uterine blood means when wife has a 2 different husbands and both are delivering a child, that is called uterine blood. Uterine blood. Section 3(1) of Hindu, 2 persons are said to be related to each other by uterine blood when they descended from a common ancestor by different husbands. There's a woman having 2 husbands at a time, one or another, giving birth to a children created called uterine blood among her children. So egnate, cognate, full blood, half blood, uterine blood. So मैंने major concept समझा दिया. Okay. Now the whole game starts here. If a male dies intestate, firstly it will go to class 1 of the schedule. Class 1 में नीचे discuss करता हूँ. Class 1 में क्या आता है? Class 1 में जो भी है वो एकदम like father, son, इस तरह से है. इसमें सबका 1 unit होता है. Secondly, if there is no hair of class 1, class 1 में कोई नहीं है, तो then it will goes to class 2 relative. Class 2 में क्या होता है? Class 2 में ABCDE है. इसमें class 2 में जो भी relative ABCD A वाले को पूरे का पूरा right, A नहीं है तो B में जाएगा. B में 3 है तो 3 का 1/3 होगा. 2 है तो 1/2. Third है तो third में 2 classes है. Okay. So first thing is when a male dies intestate, firstly it will go to class 1 on the basis of 1 unit each. We will explain. If there is no class 1, then it will go to class 1. Class 1 का class 2 का कैसे distribute है वो बताओ. And thirdly, if there is no hair of class 1 as well as class 2, then it will go to egnate of the deceased. अगर egnate भी नहीं है तो cognate जाएगा. अगर cognate भी नहीं है, then it will devolve to the government, will take away the property. So are you clear? When male dies, class 1, class 2, then egnate, cognate, and this thing. Egnate and cognate में मैंने पहले समझा दिया है. इसका definition एकदम clear है. ठीक है? Now, okay, this is E is over. The order of succession among heirs in the schedule. Among the heirs specified in the schedule, class 1, I shall take cemeteries in the exclusion of all the heirs. Those in the first entry, class 2, shall be preferred to those in the class of a second entry. Class 2 में first entry, second entry, third entry इस तरह से होता है. Distribution of property among the heirs in class 1 of schedule. Firstly, upon the heirs being relative of each other, class 1, of all rules are as under. Class 1 का rules इस तरह से है. the intestate widow, or if there are more widows, then all widows together shall take one share. अगर एक widow है तो one, two widow है तो two, but widow one इसका one half share आएगा. अगर one widow है तो one itself. If there are two sons, the two sons would have one each. So one widow, one, two son, two, three. If there is no daughter, one third ले जाएंगे. Okay, that is the way. If there is two son and one daughter, so one widow, two son and daughter, so total 1/4 share हो जाएगा. बराबर clear? Yes, no? Yes. So rule 1 and 2 is clear. And the mother of intestate shall take also one share. So there is one widow, one mother, two son and child. तो पांच mother, पांच हो गया. Widow, mother, two son and child and daughter. तो 1/5 share each जाएगा. The heirs of the each branch of a predeceased son and each predeceased daughter in the estate shall be taken between them as one share. So if there is a son is also married, तो son को जो one share मिलता है, उसका जो share है one wife and two daughter and one son, तो उसके अंदर ये divide हो जाएगा. अगर मैं बताऊं कि now it is a son having two daughters, son having two sons, मतलब grandson, wife, तो ये 4 share हो गया. Wife, two son and self 5 share हो गया. बराबर है. Self, son is himself, two grandson, wife, तो 4 share हो गया और one daughter, तो 5 हो गया. उसका जो शेयर है उसका 5 में 1 शेयर का 1/5 ले जाएंगे. Now if son is no more, तो भी ये जो उनका जो 1 है उसका 1/4 सबको मिल जाएगा. So rule 3, each branch will get his share in the share which I have mentioned here. Rule 4, the distribution of share referred in rule 3 among the heir in the branch of predeceased son shall be so made that his widow and the surviving son and daughters get equal portion and the branch of predeceased son get the same portion. Now I am talking about among the heirs in the branch of a predeceased son shall be so made that his widow and the surviving son daughter get equal branch and the branch of predeceased get the same proportion. जो मैंने पहले बता दिया कि 1/4 सबको आया, इसमें सन इज नो मोर, बट इसकी जो ब्रांच में जो है वो सबको अंदर मिल जाएगा. 1/4 का जो भी शेयर होगा. Among the heirs in the branch, the predeceased daughter shall be made the surviving son and daughter in equal proportion. डॉटर है तो भी इसका इतना ही वो बनता है. Distribution of property heirs in class 2 of the schedule. Secondly, if there is no heir in class 1, then there has been relatives specified in class 2 of the schedule. अब class 1 में तुम्हारा कोई relative नहीं है, then it will go to class 2. The property in the intestate shall be divided between the heirs specified in any one entry of class 2 so that they share are equal. Okay, clear? Yes, no? Should I sell? क्लियर, इसमें कोई ज्यादा प्रॉब्लम नहीं है. क्लास 2 में है, वो क्लास 2 का एग्जांपल भी मैं आगे बताता हूँ. नाउ आई एम गोइंग इनटू दिस, द ऑर्डर ऑफ सक्सेशन अमंग द एग्नेट एंड कॉग्नेट. नाउ सेकेंडली, if there is no heir in 2 classes, then upon एग्नेट ऑफ द डिसीज, एग्नेट एंड कॉग्नेट, बराबर, एग्नेट नहीं तो कॉग्नेट. अब एग्नेट और कॉग्नेट में भी प्रॉब्लम क्या होता है कि फादर का, सपोज आई एम माई सेल्फ, माई फादर, माई ग्रैंडफादर, great grandfather, son, grandson and great grandson. My father and son got an equal क्या बोलते हैं, equal the order of cognitive succession. The order of among the egnate or cognate as the case may be shall be determined according with the rules of preferred laid down thereunder. Lastly, okay, so if there are 2 heirs, now so I am 0, my father and my son will get equal degree 1. My grandson would be 2 and my grandfather will be 2 degree. तो इस तरह से डिग्री गिनी जाएगी, रूल ऑफ डिग्री. तो आई एम हियर इन रूल 1 called degree. Father and son are equal in degree because I am 0, फादर एंड मदर, इसके अगर ग्रैंडफादर एंड ग्रैंडसन इज इक्वल ग्रेट ग्रैंडफादर तो डिग्री 3 हो जाती है. तो इट वुड बी फॉलो इन द सीक्वेंस ऑफ degree where the number of degree ascent in some same, none that are preferred who are fewer than no degree of descent. तो if I am there तो मेरी no degree 1 degree उसको पहले प्रेफरेंस मिलेगा, 2 degree को सेकंड में. when neither heir is entitled to be preferred to other under rule 1 2 they take simultaneously. तो 1 1 है वो simultaneously जाएगा. For the purpose of determining the order of succession among the ignorant organs, relations shall be reckoned from the intestate to the heir in terms of degree of ascent and degree, which I have already discussed. Degree of ascent and degree shall be computed inclusive of intestate. So मैं जो हूँ इसके ऊपर मैं intestate गया तो इसके बारे में है. Every generation को मैं मेरा example इसलिए बताता हूँ कि you will be able to correlate as you are and your go and plus minus, because what is more important is not content but contextually your understanding, then it becomes an easy thing for you. अब class 1 किसको बोलते हैं? In this schedule, reference to brother and sister do not include reference to brother and sister by uterine blood. Uterine blood हमने समझाया था कि wife if female marries to husband then it will be uterine brother and sister, okay, full blood. But husband marries to then half blood. Son, daughter, widow, mother, son of a predecessor son, तो ये सब इक्वल में आएगा. Son 1, daughter 1, widow 1, mother 1, son of a predecessor 1, daughter of a predecessor son 1, son of a predecessor 1. अगर ये सब आएगा तो उसको क्लास 1 गिना जाएगा, इसको 1 इक्वल जाएगा. इसके अंदर बाद में अंदर सन का जो भी पार्ट है, सन को 3 सन है, 3 डॉटर है, 1 विडो है, 1 वाइफ है, तो उसमें अंदर अंदर गिना जाएगा. दिस इज हाउ क्लास 1 इज ऑलवेज जितने भी मेंबर है इसको एक राइट मिलेगा, ठीक है. एंड फिर उसके 3 है तो 3, देन इसके अंदर ब्रांच होके जाएगा. दिस इज शेड्यूल 1 इज वेरी क्लियर. शेड्यूल 2 इज अगर फादर है तो फादर को सब कुछ मिल जाएगा. अगर फादर नहीं है then it will go to son's daughter's daughter, brother, sister. अगर इसमें से 2 है तो अगर तुम्हारी प्रॉपर्टी 2 है तो उसको 2 में 50-50 मिलेगा. फादर को कुछ नहीं मिलेगा, 3 में किसी को भी नहीं मिलेगा. it would go by schedule. फर्स्ट में नहीं है तो ही दूसरे को मिलेगा, दूसरे में 2 है तो 2 को मिलेगा, 1 है तो 1 को सब कुछ मिलेगा, कोई नहीं है तो 3rd में जाएगा. 3rd के बाद 4 जाएगा. फादर आई एम नॉट डिस्कसिंग ऑल इन डिटेल बट दिस इज अ क्लास विच यू नीड टू अंडरस्टैंड. फादर, सन्स फादर, क्लास एंट्री 2, एंट्री 3, एंट्री 4, एंट्री 5, एंट्री 6. फादर्स मदर, फादर्स विडो, फादर्स ब्रदर, फादर सिस्टर, मदर्स फादर. इसमें 3-4 भी हो सकता है, ऐसा नहीं है कि एक ही है. मदर इसमें 1-2 जो भी है वो. Mother's brother, mother may have 2 brother, mothers have 5 sister. तो ये 10 में अगर 9 में अगर 8 है तो 8 को जो भी है वो सब प्रॉपर्टी इक्वल जाएगी. सो क्लास 2 इस तरह से होता है. अब तक जो हमने डिस्कस किया was related to male dying intestate. Now I am discussing a property of a female Hindu to be honored to be her absolute property. This is applicable to female only. Okay, this is the way it will go. Now I am discussing about पहले जब तक जो भी था वो मेल के लिए है. Now 14(1) apply to female to be absolute property. अब तक जो पहले था वो फीमेल को पूरा राइट नहीं था. Now section says any property possessed by a female Hindu, whether acquired before or after the commencement of the shall be held to be her full owner thereof and not limited owner. पहले क्या था कि फीमेल को खाली मेंटेनेंस का ही राइट था, बट नाउ सिंस 2005 she has a full right over the property. Expression in this subsection, property includes both movable as immovable acquired by a female Hindu by inheritance or device or a partition in lieu of a maintenance or areas of maintenance or by gift from any person, whether a relative or not, before or after marriage, by her own skill or exertion, or by purchase or prescription, or any other manner, whatever, any name called, held by her as treason immediately before the commencement of this act. Nothing in containing shall apply to any property acquired by way of gift under will or any other instrument under decree of court. ये सब 14(1) में जो उनका जो पूरा राइट था, बट अगर डिक्री ऑफ कोर्ट है तो इट विल नॉट बी कंसिडर्ड एज अ full property, but it is restricted to the order passed by court or decree. 14(2) is a restrictive clause. Now, general rule of succession in case of male हमने बोला था as per class 1. Okay, यहाँ इन्होंने इसका 5 है वो लिख के दिया है. In case of a female die intestate, firstly it will go to son and daughter, including children of a predeceased son and daughter. अगर एक फीमेल मर जाती है तो उसका सन और डॉटर को मिलता है. अगर सन मर गए, उसका डॉटर है और सन का वाइफ है, तो इंक्लूडिंग चिल्ड्रन ऑफ ए प्रेडिसेसर सन, उनको ये राइट मिलेगा एंड द हस्बैंड. सो ए फीमेल डाई इंटेस्टेड, इनके 2 सन है, एक डॉटर है, हस्बैंड है, तो ये 2 सन, ए 1 डॉटर 1 एंड हस्बैंड 4, तो ये 1/4 में गिना जाएगा. बट इसका एक सन है वो एक्सपायर हो गया है 3, बट उसका ग्रैंड सन है और ग्रैंड डॉटर है, तो उसका राइट इसमें 1/4 में आ जाएगा. उसके हिसाब से उनको मिल जाएगा. दैट सन हु डाइड हैज गॉट 2 सन एंड 1 डॉटर, तो और तो इसको विडो, तो उनको ये 1/3 मिल जाएगा. सेकेंडली, अपॉन अगर फर्स्ट में नहीं है तो इट विल गो टू हेड्स ऑफ ए हस्बैंड. हस्बैंड के हेयर का जो मेल का जो है वो उसके डिस्ट्रीब्यूशन में जाएगा. ओके, क्लियर? यस नो? इट विल गो अकॉर्डिंग टू द हेयर जो हमने क्लास 1, क्लास 2, इग्नेट, कॉग्नेट, एंड कुछ भी नहीं है तो वो इट विल गो टू गवर्नमेंट. क्लास 1, क्लास 2, इग्नेट, कॉग्नेट एंड गो है. ओके, इन दिस केस सेकेंडली इज अ मदर. अगर उसका सन भी नहीं है, हस्बैंड भी नहीं है, हस्बैंड भी कभी कोई हेयर नहीं है, देन इट विल गो टू हर मदर एंड फादर. फोर्थली, अपॉन द हेड्स ऑफ द फादर. फादर नहीं है तो फादर के हेयर को जाएगा, और मदर भी नहीं है, फादर भी नहीं है तो मदर के हेयर को जाएगा. हेयर कोई नहीं है तो ठीक है. दिस इज द वे रूल फॉलोस. ओके, this is the rule regarding, up till now it was a male, and this is about female. Any property, now this is rule number 2. Any property inherited by a female Hindu from her father or mother shall devolve in the abeyance of any son, in the absence of any son or daughter of the deceased, including children, not upon the heirs of transfer to one, the order of specified, but upon the heirs of the father. अगर एक फीमेल एक्सपायर हो गया, उसके सन और डॉटर नहीं है, देन द प्रॉपर्टी विल गो टू फादर्स हेयर. क्योंकि ये प्रॉपर्टी फादर के पास से आई थी तो उन्होंने फादर्स के हेयर को दे दिया. नीचे अगर हस्बैंड के पास से आया तो हस्बैंड के हेयर को दे दिया. सो दीज आर द ओनली डिस्टिंक्शन इन द केस ऑफ अ फीमेल. अगर फीमेल को फादर की तरफ से कोई प्रॉपर्टी मिली है एंड इसका सन और डॉटर कोई नहीं है, then it will devolve to father's hair. And अगर मदर हस्बैंड के साइड है तो हस्बैंड के हेयर को जाएगी. So these are the only distinction between A and B here. Rest will follow this. Now, among the hair under section 150, those one entry shall be preferred to those in succeeding entry, and those including the same entry shall be taken simultaneously. जो हमने ऊपर पहले में जो था हस्बैंड में था वही रूल यहाँ है. इफ एनी सन और डॉटर of the intestate predeceased, the intestate leaving her husband own children alive, वो हमने पहले लिए वही है, अपने यहाँ नहीं बोलते. We are not going to talk on special law because it is a subject on its own, because these are very fights, less than 5% of the cases. That's why we have not discussed this Mariam law and Elysian law. Okay, now we are going into general provision of the act. अभी तक हमने मेल इंटेस्टेड क्या हो गया, फीमेल इंटेस्टेड क्या हो गया, वो बताया. नाउ जनरल प्रोविजन रिलेटिंग टू सक्सेशन, फुल ब्लड, half blood, uterine blood. The heirs of full blood will be preferred over half blood. हाफ ब्लड के ऊपर यूट्रिन ब्लड लास्ट में आएगा. ओके, वो मैंने हाफ ब्लड, फुल ब्लड, यूट्रिन ब्लड क्या होता है वो मैंने इंटेस्ट समझे. Mode of succession or two or more. If two or more heads succeed together, then per capital will be preferred and not per strip. You can provide that the beneficiary inherit though either per capital or per strips. The reason the two types of beneficiary designated can have very different effect in terms of who inherit your estate. Here is an example I have given. Is A dies intestate, C and D is there, B is not there, but B को दो हेयर है. Okay, B is deceased, A is deceased, B is deceased. Then ये वन थर्ड पर कैपिटा, ये 1/6 पर स्ट्रिप्स गिनी जाएगी. पर स्ट्रिप्स मेथड, ये इसको पर कैपिटल होता तो वन थर्ड मिल जाता. Per capital is a Latin phrase that translates literally to by head. It doesn't go by this way, but this example is per strips. नहीं तो ये नहीं है तो ये 1/4 जाएगा. पर कैपिटल इसको 1/4 बोलते हैं. Tenants in common and not as joint tenant. You know, when what is between common means there is no distinction. Joint means you are jointly holding the property. Joint means the share of the property is in the joint name, joint tenant. Suppose I have 1/4 share and one may have a 3/4 share, but common means everything is equal. Okay. ये इन्होंने जनरल प्रोविजन रिलेटिंग टू सक्सेशन है, उसमें भी इन्होंने राइट ऑफ ए वोम लिखा है. ये जनरल प्रोविजन है जो हमने मेल में बताया, फीमेल में बताया. दिस आर नॉर्मल प्रोविजन वुड बी अप्लाई टू हिंदू सक्सेशन एक्ट. और राइट हिंदू सक्सेशन एक्ट किसको बताया वो भी हमने लिया, किसको लगा किसको नहीं लगता है. सो नाउ दिस इज द राइट ऑफ ए चाइल्ड. एक आदमी मर जाता है, बराबर है, तब उसके फीमेल में वूम में अगर बच्चा होता है तो तो उसका भी इतना ही राइट बनता है एज इफ ही इज अलाइव व्हेन द पर्सन इज डेड. सो दे कंसीडर लाइव इन वूम rather than live in physical terms. डेट ऑफ बर्थ सर्टिफिकेट नहीं गिना जाएगा. वूम में जब पैदा हुआ वो around 9 months. So a child who was in womb at the time of a death of an intestate who subsequently were alive shall have the same right to inherit the intestate as if he had been born before the date of intestate. And the inheritance shall be deemed to vest in such a case with effect from the date of death of an intestate. So clear, date of birth certificate नहीं गिना जाएगा, but around 9 months time from womb or is the death of death गिना जाएगा. Presumption in case of a simultaneous death. So many times you fly in a airport or a plane or you die in an accident. तो पहले कौन मर गया वो पता नहीं है, या आपके पास date of death certificate नहीं. In that case, the prevalence of elder would have died first would be assumed, then the later. If you have a proof that X die first and Y die second, it would prevail. But if you don't have any proof, then elder die first will be presumed as per section 21. Certain widow remarry may not have inherit as widow. Who are the heirs? Who are the person who would be assumed to have been deleted? Is written here. Any heir who is related to intestate is the widow of a predeceased son, the widow of a predeceased son of a predeceased son, or the widow of a brother shall not be entitled to succeed the property of intestate as such widow if on the date of succession open see married. On the date of succession means the date and the person dies and the testation is intestate. तब ये provision लगेगी on the date of death, whether she is married or not. Before or afterward, it will not take care. preferential right to acquire in property in certain cases. Section 22 says, where after the commencement of this act, any interest in any immovable property of any intestate or any business carried on by him or her, whether solely or in conjunction with others, devolves upon two or more heirs specified in class 1, and any one of the heirs proposes to transfer his heir right in the property of business, the other shall have a preferential right to acquire the interest of the property so transferred. क्लास 1 की प्रॉपर्टी क्लास 1 में है तो उनको पहले बेचने से पहले इनको ये राइट देना पड़ेगा. They cannot sell it otherwise. The consideration for which any intestate of the deceased may be transferred under the section shall in the absence of any agreement with the parties be determined by the court. अगर तुम्हारे बीच में जो एग्रीमेंट नहीं होता है तो कोर्ट विल डिसाइड, एंड कोर्ट डिसाइड करने का जो भी खर्चा होता है वो जो आदमी लेने के लिए बोलता है उसको खर्चा पे करना पड़ेगा. सेक्शन 22. If there are two or more heirs specified in class 1 of the schedule proposing to acquire interest under this section, then their heir who offer the highest consideration, क्लास 1 का जो फादर मदर जो पूरा राइट है उसमें जो सबसे ज्यादा पैसा मिलेगा देने के लिए तैयार है उसको ये प्रेफरेंस मिलेगा. इन दिस सेक्शन कोर्ट मींस द कोर्ट विद द लिमिट ऑफ जुरिडिक्शन व्हिच वी विल नॉट डिस्कस हियर. Specific provision respective dwelling houses where a Hindu intestate is left surviving him, both male as well as female heir. Where a Hindu died intestate has a dwelling house with his son and daughter, both male and female, in class 1 of the schedule, and his or property includes a dwelling house wholly occupied by the members of his or family, then notwithstanding containing any other act, the right of any such female heir to claim the partition of the dwelling house shall not arise until the male heir chooses to divide the respective share therein. अगर dwelling house है, अगर joint house में रहते हो तो male member only deciding factor for selling the house, whereby in their respective shares, but the female heir shall be entitled to a right of residence. फीमेल को वो घर में रहने का राइट है, provided that where such female heir is a daughter, she shall be entitled to right of residence at dwelling only if she is unmarried or he has been deserted by or separated from her husband or is a widow. तो 1 person died intestate, इसका एक dwelling house है, इसमें सब लोग रहते हैं, female and male only can sell the property, and female has all the right to stay in the house if she is not married or has been deserted or has been widow. Murder. Suppose I give you an example here under section 25. X murders Y. Okay. X ने मर्डर किया Y का. Y की कोई प्रॉपर्टी है से A में X का कोई राइट है. Then because he murdered Y, he will not be entitled to any right in property A. Okay. And murder include abetment to murder. Okay. मर्डर किया है और मर्डर का कोशिश किया है, दोनों केस में he will not be entitled, X will not be entitled to Y's property A, because if the Y other properties will be still entitled. Okay. So a person who commits a murder of abets and commission of murder shall be disqualified from any property or any other property further success to such committed abatement. Converts descendant disqualified, where before or after the commencement of the Hindu has ceases to be a Hindu. Okay, let me give you an example of this. अगर एक आदमी A आदमी है, he has chosen not to be Hindu. Okay, now he has become non-Hindu. He has got a 3 child. Okay, and A and B and C is the child. A and B chooses to be Hindu, again to Hindu, and they are Hindu as per act. And if any property on the date of an intestate property, A and B are Hindu, they would have a right to property. If C is a person, C is a child, E is not an Hindu, then she will not be entitled, she would be disqualified under section 26. A and B person, child, would be entitled to property. Succession when heirs disqualified. If any person disqualified, it would be seems that he is no more there. Any disease or defect not qualified, they are not there, which I have said it earlier. When class 1, class 2, cognate कुछ भी नहीं होता है, तो फिर ये property government को जाएगी. If an intestate is left, no heir qualified to succeed. And in case of woman भी हमने discuss कर लिया है, to his or her. In accordance with the provisions of the Act, such property will revert to government, and the government shall take over subject to all obligations and liability to which inherits would have been the subject. Testimony succession. One person died testament, उसने will बनाया है, और will में किसी को कुछ right है, और वो भी right उसको नहीं दिया है, but still she would be entitled for maintenance right as per Hindu Succession Act. Though testimony हुई है, he has written a will, but in a will he has not given a property to A, and A has a right to maintenance. Then, as per this act, that person would be entitled for maintenance. Any Hindu may dispose of will by will or other testament dispose any property which is capable of being disposed of by him in accordance with the provision of the or any other law for the time being in force, call Hindu. For the removal of it is by declared that nothing under shall affect the right of a maintenance of any heir specified in the schedule by reason only of the fact that under a will or under testimony disposition made by this is the heir has been deprived of a share in the property which he was entitled for if he died intestate. उनको अगर प्रॉपर्टी में कोई रेट नहीं है पर उसको मेंटेनेंस का राइट रहेगा. Now we are going into certain judgment which have come into effect. Now after 2005 amendment, however, now the woman is on the same footing as that of a male descendant, and there remains no reason here not a karta. In the case of Mrs. Sujata Sarma versus Manu Gupta 2011, the court stated that a clear and ambiguous interpretation to the object and the goal of amendment section 2 by extending to not only including Hindu women as a co-partner, but the eldest co-partner can be a karta of HUF. So woman can be a karta, not only a co-partner. Conclusion of all this thing. I'm going to the further judgment, but the patriarchal जो society थी, उसको अभी उन्होंने वुमन को इक्वल जेंडर इक्वालिटी खत्म कर दिया, फीमेल को इक्वल राइट दे दिया. नाउ आई एम गोइंग रीडिंग फॉर द सेक ऑफ रीडिंग, बट इट्स नॉट इम्पोर्टेंट, बट द वन लाइनर इज दिस. द पार्चेस कंसिस्टिंग ऑफ कॉन्सेप्ट ऑफ हिंदू जॉइंट फैमिली, हिंदू अनडिवाइडेड फैमिली, को-पार्टनर करता. Co-partner means whether a female or male gender are always a co-partner by birth. Okay, HUF is a entity. Hindu joint family is a property, and this thing. Karta is the person who is handling with the advent of 2005, especially with the enforcement of Hindu Succession Act 2004, the legislature tried to bring the putting women at par and extend equal right to women in the society. The research judgment provides clarity of object in the scope of the amendment 6 and resolve the ambiguity and ambiguousness in the interpretation of the said section by conflicting judgment passed earlier by Supreme Court. The verdict passed by the court deserves the appreciation by achieving gender equality. The judgment would have impact on pending litigation before court the subject matter and provide a speeding remedy. Co-partner and member, I said that pehle female were a member but not a co-partner, but now this concept has been disappeared. A co-partner is a person who acquires interest in by birth. The comparison between the co-partner and member of is that co-partner can enforce the partition of HUF. A member cannot enforce it. It consists mainly with a common ancestor and all lineal male and ascendant with their wife and unmarried daughter. Co-partner property is the one that is inherited by Hindu man and father's grandfather, great-grandfather. However, after Section 2005 Hindu Succession Act, vital changes have been made in Section 6 of the Hindu Succession. Before the amendment, the male member was regarded as a co-partner, whereas the daughter were not. Now both male and member are a part of this. comparison between Hindu undivided family and Hindu joint family. There is a fundamental concept of Hindu family law governed by the Hindu Succession Act 1950. It is a going on process. So एक आदमी बर्थ लेता है तो अपने आप वो को पार्टनर बन जाता है and it is brought to an employee as a part, and at the end of the partition, जब आप पार्टीशन करते हो तो ये को पार्टनर खत्म हो जाता है और मेंबर दे सेल द प्रॉपर्टी. In case of Rokhambai versus Lal Lakshmi Narayan, it is observed that a family continues to be joint family even if it is undivided by food, worship and estate. In the case of Chote Lal versus Jhande Lal, it was held that joint family is neither a corporation nor a jurisdiction person, and it has no separate legal entity from its member. They say that corporate में member आते हैं जाते हैं, co-partner में यहाँ automatic birth लेता है until it is a partition take place. The Karta is the head of the family, and all decisions are taken solely under its authority for the benefit of Hindu joint family. Karta है वो सब decision लेता है but for the benefit of members and co-partner and HUF. यहाँ Hindu undivided family, it is an integral part of Hindu society even on the basis of custom. The main requirement of jointness is Hindu is born as a co-person of the family. It is governed by the Income Tax Act 1961, which said that HUF as a person and it is different entity is separate from Karta, co-person and member. In order to run its own business, it may receive gift, profit, generated for such will be separate of the HUF. People do the planning for as an HUF, they file the return, they're using it as a strategy. It also holds a capital asset and is capable of earning a rental income. Now they're talking about a fiction of a partition. What in one liner they says that the Hindu undivided family can be cut off by partition. But government says that the partition law says that partition was done should be full, not only full, but it should be documented. And particularly since 2005, they said that it should be documented, which I will discuss later on this thing. Let me read the section here. Section 6 of the HSA said that the concept of statutory fiction of a partition of a complex mechanism as a complex mechanism is the right of a man surviving family member and he dies leaving behind only a female relative class 1, such as daughter, mother and widow. In such a case, the earlier law stated that the said property would be shared. 2005 के पहले ये लोग क्या बोलते थे कि 2005 के पहले अगर कोई भी मेल मेंबर नहीं रहा तो it would be deemed to be the total partition, as if the कोई member है जो आदमी जिंदा था. But after 2005, they said that even male member dies, the property will continue to be devolved. Okay, ये चालू रहेगा. Section 6 of HSA state that the concept of statutory fiction of parties as a complex mechanism to ascertain the right of a man surviving family member as he dies and leaving behind only female relative of in class 1 of the schedule such as daughter. In such a case, the earlier law stated that the said property should be shared or calculated by imaging that a partition took place immediately before the man's death. Hence, women did not have a share in the co-parcel property. In the present scenario, the court held that the concept of statutory fiction of partition did not entail an actual partition, and thus any statutory fiction of property taken place before the Amendment Act is not valid, and the new provision will have to be implemented in all the pending proceedings before appeal. Further, the court noted that the matter is already delayed due to conflicting decision and the daughter cannot take deprived by this thing. Hence, all pending cases appeal should be decided within 6 months. Now, what are they saying? 2005 के पहले जितने भी deemed partition थे will not be considered in deemed partition and they shall be deemed to be continued until otherwise proved and documented. This is the judgment. Now I am वो जो मैंने जो पहला 2005 के पहले मेल मर गए लास्ट मेंबर तो assume that then partition taken place. Now the law says something different. Hindu Succession Act provided a daughters of a co-partner with the same right in the co-partner property as the son. The objective behind the amendment was to change the patriarchal mindset, to remove the gender discrimination provision of Hindu Succession Act, and provide equal share to the son and the daughter of a Hindu matter relating to inheritance of the property. While this amendment brought the changes in the daughter's right, however, there was several loopholes in the interpretation. Various issues have been arising. The following is the latest development. In case of Prakash and others versus Fulavati and others. In the case of Prakash, the Supreme Court held that the amendment was prospective in nature. Hence, from the passing of date of amendment, daughter would be co-partner and have an equal share as that of a son in a joint Hindu property. The following part should be noted in this case. The daughter must be live in 2005 in order to claim the share of it. Agar 2005 में she is not and she is not there. Now he's here. 2005 के बाद का 2005 के बाद alive है तो कोई problem नहीं. 2005 के पहले expire हो गए कोई भी तो उनके heirs को ये लाभ नहीं मिलेगा. In case if the daughter dies before the enactment of this act, legal heir cannot claim the share in the property. The daughter's father should be alive during the time of enactment in order to provide the equal share of a co-partnership property. They said that 2005 में इनके father भी alive चाहिए to have an equal right. But since amendment and there are certain judgment, these are the beneficiary which they are likely to get it. The Amendment Act would not affect the alienation and disposal of transfer of joint property registered before then. It would not be affected by the daughter's claim as co-partner in the family. I am again going to next. Last में ये भी cover कर लिया है. Lokmani versus Mahadevi and others in 2000. In this case, Lokmani and Mahadevi, I could state that Section 6 of the amended Hindu Succession Act is given a retrospective effect when the daughter were denied the right in co-partner property pending proceeding and appeal to be now decided as per amended provision of inequality. The High Court also stated that oral partition and unregistered partition needs to be removed from the definition of partition mentioned in amendment of Section 6(5). What they are saying, oral partition or unregistered partition should be not be taken place. It should be not assumed. Court says that there is some document, some public document, then only allowed. Otherwise, no. In Danamma versus Amar 2018, two judgments held that two daughters would get a share in the property even though their father has passed away before the amendment. However, there was need to solve the conflict judgment in the courts. In VINEET Sharma and Rakesh Sharma, the landmark case of daughter's right to property, a three-judge bench took the notice of conflict judgment to settle the law. In the case, Supreme Court stated that Hindu Succession Act provides unobstructed heritage by birth to the daughter. Thus, the co-partner need not be allowed on 9 September 2005. The court also says that co-partner right is by birth. Thus, it is not at all necessary that the father of a daughter should be living as on the date of 2005. First 9 September 2005. As he has not conferred the right of co-partner by obstructed hemorrhage. Hence, the daughter can only claim her right from the date of amendment, and any transaction related will not be affected according to Section 6(1) of the Amendment Act. Further, the court explains Section 6(5) HSA, which states that partition only by virtue of registered partition or partition affected by decree of the court. Hence, the court can take the notice of oral partition in exceptional cases only on the basis of long-standing evidence in the form of clear public document. What court says that until there is a partition and a decree of a court or registered partition, you should not take cognizance of that until there is a clear and public document available. Also, court directed that significantly delayed due to conflict is the earlier High Court. Supreme Court had been asked to deliver the judgment within 6 months. Moreover, in the case mentioned, essential part of intent of as it was neither to benefit female success prospectively or nor retrospectively, but its main intent was to confer the benefit retrospectively While stating the Amendment Act to be retrospective, it was held that it confers the female a successor the benefit of all successors on par with her male member on their birth in Hindu family. As soon as she is taken a birth, her right arises whether her father was there alive on 9th September 2005. With this, I conclude my talk on today on Hindu Succession Act, Females' Right. Whole act is deliberated. Any issue regarding that, you can call on me on my number, my blog. This presentation would be available on blog. There you can email me, you can WhatsApp me. I'll be ready to answer. I'm a founder president of Visakha chapter. We are going to have a different subject talk. Please join our talk on different subject, including this thing. I am coming to my first slide. We are going to have on Friday 28th 6:30 Manish Naik on security, on 4th by Avichal Sinha on library to interact. There are many seminars going to come. With this, anyone wants to do CISA, CSAM, any course, we are ready to support you. Thank you very much. Thank you very much. See you once again. Thanks.